I'll start by saying a few words about our speakers. First, Justice Feehan was appointed to the Alberta Court of Appeal in 2019. Prior to that, he had been a justice of the Alberta Court of Queen's Bench since 2016. For most of his career, Justice Feehan was a star litigator with the firm that is now Denton's. He was named Queen's Counsel in 2003 and a Fellow of the American College of Trial Lawyers in 2015. He has been deeply involved in his community throughout his career. He's been Chancellor of Newman Theological College, Chair of Catholic Social Services, and numerous other boards and committees. I can also tell you that he is typically the very first person who registers for Edmonton Bar Association social events. His name's always at the top of the Excel file. So always eager attendee at bar events. Justice Grant Huscroft was appointed directly to the Ontario Court of Appeal in 2014, without so much as a pit stop at a trial court along the way. Needless to say, this is quite a rare distinction. Prior to joining the bench, Justice Huscroft was a prominent legal scholar and law professor. He began his academic career at the University of Auckland Faculty of Law, moving to Western University's Faculty of Law in 2002. His research and teaching focused on constitutional and administrative law. He published widely in these areas. He was Associate Dean at Western from 2006 to 2008 and founded the Public Law and Legal Philosophy Research Group with then Professor Bradley Miller in 2008, now his colleague on the Ontario Court of Appeal. So these are two of the most esteemed appellate judges in the country, I think it's fair to say. If you were drafting a team of appeals judges, I think these two would both be first rounders. So we're very lucky to hear what they have to say. And there's a strange kind of symmetry in how their judicial careers intersected with today's topic. Both the Ontario Court of Appeal and the Alberta Court of Appeal heard reference cases on the constitutional validity of the Greenhouse Gas Pollution Pricing Act, the GGPPA, the federal carbon pricing regime. Both courts sat in panels of 5 on their references, and both courts decided the case 4-1, with the Ontario Court of Appeal deciding the act was constitutionally valid and the Alberta Court of Appeal deciding that it was not. Justice Feehan was the sole dissenter at the Alberta Court of Appeal. Unlike his colleagues, he would not have upheld the act. He would have upheld the act. My apologies. Justice Huscroft was the sole dissenter at the Ontario Court of Appeal. In other words, he was the only one who would have held the act to be unconstitutional on that court. So clearly, neither of these judges is susceptible to peer pressure. The format we'll have for today's discussion is straightforward. I'm going to pose a series of questions to our panelists. We'll then turn the discussion over to the audience. We do have to bear in mind, though, that our panelists are both sitting members of the judiciary, and I have promised not to get them in trouble. So they won't be able to comment on future issues that might come before their courts, but I think that still leaves us plenty of room for fruitful discussion. So I'll open the discussion with Justice Feehan and simply ask, why does environmental regulation present recurring issues in the division of powers?
I think that environmental regulation is going to be an area that we're going to see many, many more challenges on. And the reason why is because, A, it is an important and pervasive problem. The Supreme Court in the GGPPA case called it an existential issue. And the second big reason is that Section 91 and Section 92 of the Constitution Act of 1867 do not assign any particular areas of jurisdiction with respect to the environment, so that the environment is such a big topic that is not covered in 91 and 92 that we have to continuously try to figure out where it fits jurisdictionally. Because very, very clearly, both levels of government have exclusive power over the environment within their own jurisdictional parameters. Neither of them have plenary power. And so there will continuously be a give and a take, a back and a forth. Where are the lines between the feds and the province? And that's just what federation and confederation is all about. So this will be a constant, from my point of view, a constant issue that will go on forever during Confederation.
First of all, I'd like to thank the Centre for the invitation to be here today. I've been out here for the week. I've had a fantastic week. I want to thank my friend Justice Feehan, who showed me around the Court of Appeal, introduced me to some of his colleagues. I want to thank Gerard Kennedy for his hospitality during this visit, and I've had some teaching with Gerard. It's been tremendous. I'm delighted to be here with Professor Lavoie, whose work I admire and who I'm delighted to be doing your last academic event with, which is an honor. Now, having said all of that, I'm absolutely bemused to be in the position of being the guy from Ontario coming out here talking about environmental or regulatory stuff in an Alberta crowd. I thought after I agreed to do this, I must be crazy. And Justice Feehan's been really nice to me, and I thought, he's setting me up, he's going to put the boot in. And, you know, you're going to go after the Ontario guy. But I just want it known that I was the guy that stood up for provincial rights in Ontario. I want you to think of how difficult that would have been. You know, anyway, enough said on that.
I've got to tell you that it was equally difficult to be on the other side, standing up for federal rights in Alberta.
Well, look, I am also aware of being I see in the audience people like Professor Adams, all sorts of folks who know more about this than I do. And I mean this when I say this. I'm an old constitutional law prof, but you know, this federalism thing doesn't come up all that often, especially peace, order, and good government. When this came up, that was a once-in-a-lifetime case. I dare say you and I will never get such a case again. Or, even if it did come up, maybe you and I would get off the panel, I'm not sure. But in any event...
we'll both be at the Supreme Court of Canada together, and then we can make the real decisions.
I'm thinking that's unlikely. But in any event, you know, when I used to teach federalism, sort of this is a big long wind-up to a short question, but when I used to teach federalism, it was a bewildering array of doctrine, frankly. And there was two ways to do it. There was to go through it and critique it, or to go through it and pretend that there was a seamless thread running through the whole thing, and if you're smart enough, you'll pick this up. And that, I'm afraid, it's just not so. And when I was preparing for today, and I had to reread the greenhouse gas reference, and I might add, reread what I'd written 4 years ago that I hardly remembered, and then read the assessment, IAA, I'm bad with acronyms. Rereading that, I thought, my goodness, a stranger versed in constitutional law from another Commonwealth jurisdiction would look at this and say, what on earth is going on? It's hard to follow. And I can't pretend that it's all wonderfully coherent. I think there's real, there's real problems in the doctrine. And so one of the things we'll be talking about is what the predictive value of all of this is and why are there different outcomes in these cases. Federalism is difficult at the best of times, but it's also revealing different normative conceptions of the way people think the country ought to be run. And so I think reasonable people can disagree. And I'm hoping you're one of them.
Reasonable or disagreeable?
Well, I know you're disagreeable. It's the reasonable part I'm hoping on. But you think historically to some of the debates between Bora Laskin and William Letterman that underlined much of the anti-inflation reference. And you just see sort of smart people in good faith with major disagreements about the way the Federation ought to be shaped. And so that, in part, explains a lot of this, which is to say, I can lay out my argument for how I think the thing works best, and you can lay out yours. And, yours might be better, but it's not demonstrably provable in a way that I just have to accept it. And I like to give this example. It's not like physics. I think it's physics. It's not E equals MC squared stuff. Here's my conception of federalism. You can't prove it's correct. I can prove E equals MC squared, or at least I could if I knew anything about physics. But it's not like the natural sciences. So reasonable people are going to disagree. Now, I think my conception is better than his, But there it is. He thinks this is better than mine, and I hope we're both in good faith on that. So, that's the what I wanted to say by introduction. Why it's hard, I agree with everything that Justice Feehan said. And I'm likely to do that for many more of the questions. As I go on.
Okay, great answers. Slight correction, the golden thread that runs through Canadian federalism is the economic vision of the Constitution. I can direct you to a book about that. Okay, so we've talked about environmental regulation in general. I want to sort of drill into greenhouse gases in particular, because that's the case that you both wrote on. What is it about greenhouse gases as sort of a policy issue, a policy challenge that presents difficult issues for the division of powers? Why has this become the locus of so much of the contentious debate around the division of powers? I'll start this time with Justice Huscroft.
I'm almost back to thinking about some introductory things I wanted to say. I mean, you can't help but notice if you look at the greenhouse gas litigation, 3 provinces and a combined score of 8-7 when it goes to Ottawa. And then 6-3 in Ottawa, sort of a 6-2-1 split. That's reasonable people disagreeing in good faith about how this all works, right? And again, you can't prove that the one side is correct. It might well be a better answer, but you can't prove it's correct such that anybody in good faith must accept that that's the way federalism is to be done. So nothing in the greenhouse gas case is the last word on federalism by any means. I don't think, it's arguable at least, this is me academically talking, it's arguable that that case was not in line with some of what they'd said earlier. I think reasonable people could think that. In any event, why is this a problem? Why is greenhouse gas in particular a problem? Because it affects absolutely every aspect of provincial governance. Everything from manufacturing to mining to farming to heating your house, driving your car. These are all, everything that he's emitting greenhouse gases is provincial and regulated under other heads without question. So no matter what is going on in terms of regulation, it's going to hit hard on various provincial things. And you see the way that's playing out in provincial politics on an ongoing basis. It's not as though once the decision was made to put it under the peace ordering of government, everybody says, well, we don't now care about how this affects provincial life and our economies or anything like that. It's a flashpoint politically for ongoing confrontations and difficulties, and I think we continue to see that.
While the underlying topic is greenhouse gases and climate change and the weather that we've been having and the fires and the floods and everything, but that was not what the Act was all about. That was the underlying problem. What the Act was all about was a pricing mechanism. And so the most important thing about the Greenhouse Gas Pollution Pricing Act is not greenhouse gases. It's Pollution Pricing Act, because that's what the Act was all about. It had to deal with an underlying problem, which is a very serious problem, and I agree with everything you said about the problem itself, but that was not what the court had to think about. What the court had to think about was this. It acknowledged right up front that greenhouse gases is a problem that both levels of government have to address. They said that primarily it is a matter that falls under provincial jurisdiction. Sections 92, 10, 13, and 16, I think. But then it said, we can't rely upon every province treating it the same way, to the same level. So we're going to let the provinces do what they want to do to deal with the problem, but we need to put together a federal backstop. So the provinces have primary responsibility. We want the provinces to do what they want to do. They can do cap and trade, they can do emissions pricing, whatever they want to do. We just want to make sure that there's a level playing field at the end of the day, and so we're going to put in a federal backstop on it. And why do they think that they should put in a federal backstop? Because greenhouse gases don't stay within the province of Alberta. They don't stay within the province of Ontario. Greenhouse gases float around. They're part of the atmosphere. And therefore, there was a concern that the provinces all had to be doing their job. And if they were doing their job, great, the feds do nothing. If they're not doing their job, the feds step in with the backstop. After acknowledging that this is primarily a provincial role. And the backstop is only there under POG because of a concern that every province won't deal with it properly and fairly. And that's why it really is not about greenhouse gases at all. It's about putting in a stringent pricing mechanism to make sure that every province ends up, at the end of the day, being treated fairly and reasonably and doing the same thing, rowing in the same direction on the matter. And that, I think, is what the importance of greenhouse gases is, but not the importance of the Act. The importance of the Act is the pricing mechanism, not the gases piece.
I can't agree with that. I think that's at the heart of the disagreement in the cases. Well, I'm going to make a general observation about peace, order, and good government. You know, we've developed some Byzantine doctrine around something that is boilerplate constitutional language in Commonwealth constitutions. And I can assure you, it's, for example, in the Australian Constitution, it's in the Barbados Constitution, I think it's in the Samoan Constitution, it's all over the place. And it doesn't mean what it means here. This is all an edifice of doctrine that's really difficult, and we've created it. And what you see is lots of difference about how it works, and the problem basically is that it's a takeover of provincial powers and the acknowledgement, the recognition of a new federal power. And he's underplaying that, my friend here is underplaying that. In any federation, you have to accept that some things get done differently than you would like to do it if you're the federal government. There's different provinces, different governments, different theories from time to time as to addressing a whole host of things. But I think on your argument, the feds would have taken over inflation with the anti-inflation legislation under the Peace, Order, and Government Clause, and that would have been outrageous. So that's my provocation.
Thanks. That's good. That's great. And it sort of leads to a follow-up on what both of you said. What I heard was, first of all, this is a policy challenge that affects everything, and there's a potential here for a federal takeover of vast areas of what has been traditionally provincial policymaking. On the other hand, I heard a story that's basically a story about an externality, right? That activities in one locality have effects on other localities, and standard economic theory would suggest that's a problem, that the emitting jurisdiction wouldn't necessarily take full account of the costs of those emissions if they're being incurred by those in other jurisdictions who don't have a vote in, say, the provincial legislature. I wonder if there's a way to reconcile these. I mean, there are clearly two valid sets of concerns. If there's a way to reconcile these in doctrinal terms, is there a way to address, say, the externality while giving sufficient weight to local autonomy concerns? Do we just have to sort of interpret our Constitution and live with the fact that it doesn't provide a mechanism to deal with the externality? Does dealing with the externality under POG have the potential to unwind local authority that's sort of been well established under the Constitution? Justice Feehan, do you want to go first?
Sure. Well, let me tell you that when I read the Act for the first time, and that was the first of like 110 times that I had to read the damn Act, I said, this is not such a big deal. This is not a fundamental change in federation. This is really a very small incremental change in the matter. And that is why I spent a lot of time thinking about the pith and substance. If you're a philosopher, what is the essence of this Act? What is the essential element in this Act? And that's why I drafted a fairly narrow pith and substance, because I thought the Act really wasn't this big radical change. It only did a couple of very, very small things. And so let me just see if I can pull up my pith and substance here somewhere. Here it is. So I said in terms of the pith and substance, the following about it. To effect behavioral change throughout Canada, leading to increased energy efficiencies by the use of a minimum national standard necessary and integral to the stringent pricing of greenhouse gas emissions. Because I didn't think it did more than that. It was simply trying to find a way to find energy efficiency by a minimum national standard to put into place a stringent pricing of greenhouse gas emissions. Now, that was, of all of the decisions across the country, that was the longest pith and substance, which is fine.
Not very pithy.
Not very pithy. Not very pithy. But it was because I thought that the Act actually did very little. The Act was very specific. It was very focused. It was putting in a pricing mechanism as a backdrop that would stand behind the province. Now, I can see why we had a different opinion on that, because your pith and substance was radically different. And if I remember correctly, I think I actually highlighted it here. Justice Huscroft's pith and substance was regulating GHG emissions, period. That's it. So his concept of the Act was shockingly broader than my concept of what the Act was. Shockingly broad.
I thought there was no hyperbole. These Alberta justices.
The longest pith and substance of all of the judges was mine. The shortest was Justice Huscroft's. And that's because we read the essence of the Act radically differently. I said, this is merely a procedural act putting in a pricing mechanism to be a backstop, nothing more. This has nothing to do with, quote, regulating greenhouse gases in the big sense. Now, the Supreme Court of Canada thought that I had put some means into my pith and substance, which I probably did. But they basically said what I said, taking out the means part of it, because they said, in terms of their pith and substance, establishing minimum national standards of greenhouse gas price stringency to reduce greenhouse gas emissions. So basically they agreed, minimum national standards, it's all about price stringency, and it's all about putting those into place as a pricing mechanism. So frankly, taking out the means that I had put into mine, they agreed that this is not a world-shaking act. This is not a world-changing piece of legislation. This is a piece of regulation to make sure that we have an even playing field across the country after we rely upon the provinces to do their job properly, and only if they don't do their job properly. Absolutely minimum regulatory issue. You're going to disagree.
This turns out to be easier than I thought it was going to be, in the sense that the lines are very clearly drawn. I disagree with everything he's just said. So I'll just go back. I'll go back and I'll set the stage for this. You know, the whole this pith and substance thing is just an arcane, overblown phrase. It's whenever you're looking at a piece of legislation and the question is it constitutional? And there's a federalism objection to it. The question is it under 92 or 91? So you got to look at what's going on. That's all. But there's this pith and substance word, this phrase that sticks around. What's going on in this legislation? And then you look at that and you say, where does it fit? Right? There was never any question that it wasn't going to fit under 91 or 92. This was a POGG case. It was there because the whole point was it doesn't fit cleanly under either. So what do you do with POGG? And the giveaway on this, it seems to me, is you look at the way the positions were argued. The pith and substance argument as to what this legislation was doing in Saskatchewan was first aired, and then by the time it got to us, the federal position had changed. And we had the federal position, plus I think they stated an alternative position, adopting one of the interveners' positions on pith and substance. I think it changed again in Alberta. They kept toying with it, as though if you state the thing narrowly enough, you can minimize the appearance of what you're doing. Whereas in fact what you're doing is you're regulating the outcome of everything in Ontario or any other province, all the manufacturing, all the mining, all the farming, they're all giving off greenhouse gases, and you're regulating that. You're just doing it by a different means. So the means is important to me, but means has nothing to do with what the matter of the thing is. And that's the view I articulated, or I tried to set out. So going through an elaborate discussion of what the means is seemed to me to be wrong, because at the end of the day, the whole point of a peace, order, and good government analysis was you need to come up with a new heading of power that the feds are going to be able to legislate under. So to describe that in terms of a very specific, lengthy description of the particular means that they have chosen is to say, in effect, you're using peace, order, and good government to constitutionalize a particular act as a head of power itself. And I fear that when I can't explain something more shortly than that, it's a problem. I think you can see the problem if you look at prior peace, order, and good government national concern cases, where the national concern is stated broadly, such that once that new heading of power is recognized, the feds know what laws they can make under it. And you don't know that you can do that when the thing is stated with the specificity that my friend here has just treating like counsel, that Justice Feehan has put it. That would, in my view, that would constitutionalize the act. So what did the Supreme Court say? They said, well, yeah, in general, the means and the matter have to be separated. But sometimes the means and the matter will overlap. But historically, and of course I can't, my memory is bad, historically, when you look at other things that were written more generally, they were one or two word matters, not a lengthy one that Justice Feehan has just described. So let me just see if I can find it. I'm just scrolling. It's funny to
Aeronautics, the national capital.
Aeronautics, let's just take, I'll use that one. Aeronautics. And now you know there's a heading of power you can legislate under called aeronautics. Not national stringency, blah, 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 pricing of how many, I don't know what that was. It's not a heading of power, though, that makes sense to me conceptually. That was my concern when I wrote what I wrote. And by the way, this is an example of, you hear a lot of cases. So this is 4.5 years ago, and I have to scroll through it and I can't even find it. And I think, oh, I said that, did I? Yeah, here it is. Aeronautics is one. Radio. There's another heading of power that was recognized under peace, order, and good government. Not regulation of FM bandwidth in order to preserve some, no, it's radio. And that's why I said, what's going on here? Regulating greenhouse gases. The means was by putting a price formula on it. But that's not the matter that is getting constitutionalized. That was my position that was rejected. So if you find that position attractive, put it right out of your head. Because the Supreme Court was emphatic in saying, that is, Huscroft is wrong, no, literally, quite so baldly, but describe the pith and substance with absolute specificity. I'm left wondering how you do that without then constitutionalizing a particular act. That's a lingering question for me.
Thank you very much. Thank you very much. That was beautifully done in sort of setting the lines of disagreement, if we can put it that way. Dangerously close to asking you to argue the brief of your separate dissents, but as long as you stay away, I did promise not to get you in trouble. So I think that sort of leads into my next question, though, right? Because this question of whether it's possible to construe the, say, POG matter in narrow or broad terms, ultimately the Supreme Court of Canada framed it in relatively narrow terms that focused on a particular policy tool. It leads to my next question, as I said, which is about the two big environment and federalism cases over the past few years, the GGPPA case and the impact assessment reference, which was relatively recently released. And the GGPPA, as we discussed, focused on a pricing mechanism for carbon The Impact Assessment Act was, I think, a lot broader than that. A sort of broad framework of assessing impacts, approving projects, potentially in areas that have been, well, certainly in areas that have traditionally been under provincial jurisdiction. And we saw that the results in those two cases were different, right? So the Supreme Court of Canada upheld the GGPPA, but recently a majority of the court held that the Impact Assessment Act was unconstitutional. And so my question to you, I suppose I'm posing a potential answer in the sort of narrowness, but relative narrowness of the GGPPA. My question is, what do you think explains these different results? How do we reconcile them? You had two regulatory regimes that were targeted at environmental effects. In the GGPPA case, specifically carbon emissions. In the impact assessment reference case, carbon emissions plus a whole host of other things. How do we reconcile these cases? How do we reconcile the different results? Do you want to go first, Justice Huscroft?
Yeah, I find this question particularly difficult, to be honest. So
you're the designated realist this evening, right?
Designated
legal realist in our midst.
So what do I say then?
I don't know about. You were saying we can't make sense of all this federalism doctrine. Reasonable people disagree.
Yeah, I wasn't surprised at the outcome in the lost the acronym. IAAA. I wasn't surprised at the outcome, just on the overbred argument that succeeded ultimately. I was struck by this distinction. I'm not sure if this is fair, but just as I was reading it, it didn't appear to rise to the level of the same concern as the greenhouse gas discussion did. When you read that case, the court refers, I think, at one point to the grave consequences of not having uniformity, and talks about national concern, and actually, I think, injected this idea that importance is part of it. And I don't think that had been understood as part of the national concern branch prior to the greenhouse gas reference. I see language like that I don't see in this case, because there's always been parallel environmental assessment things going on in all the provinces in a way that maybe explains part of the difference. But that's a partial answer. Even this case had two people in dissent. So again, these aren't easy questions. But I guess I wasn't surprised with the outcome. I thought it was substantially a different case. It wasn't presenting as a peace ordering to government case that needed sorting out. The argument on the federal side about peace ordering to government wasn't the heart and soul of the case.
Well, just to be completely controversial, I think it's easy. Just to be on the opposite side of it, you think it's not easy.
What's not easy?
The distinction between the decisions in greenhouse gases and...
I did say I was going to agree with you.
Well, did you? Okay, yeah. I'm sorry. I think it's easy because I think the Supreme Court of Canada told us in the IAA reference what the difference was. I mean, they set it out actually explicitly in paragraph 186. It reads, in the reference Greenhouse Gas Pollution Pricing Act, this court upheld a law whose matter, here we go, was limited to carbon pricing of greenhouse gas emissions, quote, a very narrow and specific regulatory mechanism. By contrast, the designated projects scheme here defined interprovincial effects lacks specificity as to the type or scale of the change to the environment that is said to be a federal effect. So what they were saying there, I think, quite clearly is, if you read the GGPPA, it's merely a regulatory backstop carbon pricing mechanism, and in their words, it was very narrow and specific. And then they say, however, what we've got before us is anything but narrow and specific. It's exactly the opposite. What we have before us, at least in terms of the designated projects, is we have a system where any project could become designated, and then the entire system gets kicked in. And they said that the overreach, the significant overreach, was in the phrase and application effect on national jurisdiction. And they said, what does that mean? that anything could have an effect on on federal jurisdiction, because everything might have some effect. And if you take that phrase at its broadest, then everything that we do might have an effect on an area that falls within federal jurisdiction. It doesn't have to be the primary effect. It can be absolutely secondary. It can be tertiary. And that's why they had a real problem in IAA. And that is, they had a real problem with the terminology, effect on federal jurisdiction, the definition of it in Section 2, and then the application of it in the second part of the act, the implementation phase, where somebody could look and say, is there any effect on any federal jurisdiction that this might have? If so, it falls under the act. But that's everything. That's everything we do. It will have an effect on an aspect of something that falls within Section 91. It's 2 steps to get to Section 91, and that's what they were concerned with. And that was the difference that they told us existed between their 2 decisions in greenhouse gases and IAA. And I think they were right.
I don't disagree with anything Justice Feehan just said, but that explanation depends on the characterization that the thing that was being upheld in the first case was as narrow as you said. Once you accept that, this explanation for the distinction between the cases makes perfect sense.